Hi, I'm Ronan. We're Group 2, and we'll be speaking about public financial markets regulation, in particular EU regulation and MIFID 2. Firstly, me and Rory will speak about MIFID and its core components. Mark will then give an overview of market abuse regulation. Finally, Marcus and Connor will take us through the LIBOR scandal and its impact on public markets regulation. Before MIFID 2, MIFID 1 was introduced in 2007. It intended to create a common regulatory framework across the EU that protected investors by improving trade transparency and mitigating market abuse. Ultimately, it aimed for improved inter-exchange competition through the introduction of new trading venues such as multilateral trading facilities, and also the reduction of trading costs and the stimulation of economic growth. However, MIFID 1 was not without its critiques. MIFID 1 was narrow in scope, with limited oversight of non-equity instruments. Its regulations in reality did not improve market and transactional transparency, while they lacked full-scale implementation across the EU. Ultimately, MIFID 1 did not improve the trading environment or protection of retail investors, and was inadequate in preventing incidents such as the LIBOR scandal. As such, MIFID 2 was developed in response, with it being fully implemented from 2018. MIFID 2 is made up of two components: MIFID itself, the Markets and Financial Instruments Directive, and MIFIR, the Markets and Financial Instruments Amended Regulation. The primary difference between the two being that MIFIR constitutes a binding legal act, whereas MIFID is a directive. MIFID 2 affects all parts of the market value chain, from pre-trade through to post-trade, while MIFID 2 also seeks market integrity through the improvement of transparency and disclosure regulation, comparative to MIFID 1's emphasis on market competition. MIFID 2 also broadens the scope of the regulations and seeks to strengthen cooperation between EU member states. However, MIFID 2's implementation garnered criticism, such as the critique of the regulation's over-complexity. Overall, MIFID 2 is made up of a couple of main elements. Firstly, its main aims. The regulations seek to improve EU market safety, transparency and efficiency, restoring investor confidence post-global financial crisis, while moving unregulated trading to regulated trading venues. The regulations affect a wide group of parties, from fund managers and banks down to pension funds and the individual retail investor. While the scope of markets affected is also broadened beyond the focus on equity markets, to include markets such as derivative, currency, commodity, and fixed income markets. Overall, MIFID 2 is composed of 5 core components. Firstly, market structure, algorithmic and high frequency trading, and transparency, which I will cover. And secondly, transactional reporting and best execution, and investor protection, which Rory will give an overview of. Firstly, market structure regulation is focused on providing new trading venues and regulating those previously lacking transparency. A new trading venue is created, organised trading facilities, designed to regulate the trading of non-equity instruments. Organised trading facilities are multilateral trading venues similar to MTFs, but they allow for matched principal trading under certain conditions. Fair and open access is a priority for trading venues under MIFID 2 to promote competition and transparency, with access only deniable when access poses operational risks. Dark pool trading is also addressed under the market structure component of MIFID 2, as volume caps at 4 and 8% are introduced to limit dark pool trading in any financial instrument over 12 months. Similarly, algorithmic and high frequency trading are given significant regulatory scope under MIFID 2. High frequency trading carries risks and benefits, as it improves market liquidity and limits arbitrage, but can lead to increased volatility and the amplification of systemic risk. It also leaves markets open to manipulation through practices such as spoofing, which create an illusion of supply and demand through a high frequency of false orders. Firstly, firm-specific high-frequency trading regulations address the registration and stress testing of algorithms for market protection, the installation of pre-trade risk controls and procedural requirements for any system failures, and also disclosure requirements for all high-frequency trades. Trading venues are also subject to specific regulations, mandating them to provide circuit breakers, minimum tick sizes, and unexecuted order caps to prevent excess volatility seen during events such as 2010's flash crash. Finally, transparency regulation under MIFID 2 primarily relates to pre-trade transparency and post-trade disclosure in both equity and non-equity instruments. Both types of instrument are subject to similar pre- and post-trade requirements, such as the publish of current bid and offer prices and the price, volume and time of transaction post-trade. However, abnormally large transactions in both equity and non-equity instruments, and non-equity transactions that would threaten liquidity, are entitled to the fair publication in the interest of market protection. Similar conditional regulation is attached to dark pools, where pre-trade disclosure is required when trading affects price efficiency. Ultimately, MiFID II's transparency regulations may have succeeded in shifting a portion of dark pool trading to OTC, as market participants seek to continue avoiding full transactional transparency. A final primary feature of MiFID II transparency regulation is the unbundling of research fees, which Rory will speak about in detail, as he takes you through the final components of MiFID II next.
In light of the financial crash, the European Union was not satisfied with the current nature of reporting standards and required for financial institutions to provide timely, concise and more detailed information on transactions. Followed by this was the introduction of the approved publication arrangement, which meant that all trade deals must be published in real time. Real-time transaction reporting means that all trade deals must be reported immediately after they have happened. Furthermore, trade deals now included bonds, derivatives, and all finance products, which meant there was a huge increase in processing, data management, and attention to detail. Moving on to the implications of transaction reporting, recruitment teams had to hire new staff in order to meet new demands, and they also had to provide on-the-job training to current employees to update them on new systems and new operations. However, the biggest implication of the new ruling was the overall cost of implementation, which will be detailed at a later point. Moving on to data requirements, the amount of data flowing in, out and around the business increased hugely, and computing, analysing and presenting this data proved difficult for employees. Traditional databases and analytical software had to be updated, or else miscalculations and data inaccuracy would begin to crop up. Additionally, the day-to-day running of these financial institutions will be altered, with the number of fields reported increasing from 21 to 65. Just like in any situation, the bigger and the more established firms are in a better situation to deal with such changes accordingly and have the appropriate resources at hand to do so. Daniel Schlepfer of the Financial Times was quoted saying that the Markets in Financial Instruments Directive 2 was driving smaller firms to the wall. Moving on to investor protection. Considering the events foregone, the financial crash in the EU and the case I mentioned, the LIBOR scandal, there was a calling for an increase and improvement in investor protection. Increased transparency for investors was seen as a necessity, although the regulation was not welcomed by many. The regulation was seen as ambiguous, with the requirements coupled with real-time regulatory reporting believed to restrict firms from unwinding their risk positions. However, investors were now covered by structural improvements. To encourage a level playing field in the industry and move to multilateral and well-regulated platforms, along with increased trading competition, meant that investors were now covered more so than ever. Product information. A major flaw between financial advisors and investors is something called information asymmetry. Information asymmetry is a situation where one person or a party possesses relevant information that the other party doesn't, and it can be used for manipulation and exploitation. Noah Smith of Bloomberg said in 2016 that asymmetric information was the dirty little secret of finance. Markets in Financial Instruments Derivative 2 requires for mandatory disclosure of product info, which would enable investors to make rational decisions. Product regulation. The rules regarding product regulation under the undertakings for the collective investment in transferable securities, otherwise known as, in short, as UCITS, were not fulfilling their primary function, and for some cases, for particular financial instruments, were non-existent. As a result, new European rules introduced three types of different product regulation. They introduced new product quality requirements, regulation of the product design, and in some cases, outright banning of the product. Finishing up with investor protection, we have service quality requirements. Often in the financial industry, financial advisors don't act in the best interest of their clients and may in fact act in the best interest of themselves for personal and financial gain. In the US, hedge funds were partially to blame for the financial crash, which eventually cascaded through Europe. An investigation into the managerial practice of these funds was carried out, and as a result, the Alternative Investment Fund Managers Directive was set up in 2011. Now, these hedge funds are in a position to sell funds across EU borders under authorization under what is known as a marketing or European passport for alternative funds. Moving on to implementation costs. In any walk of life, people find change difficult and they often resist change. Firms and even some regulators felt that this change in regulation was incompetent, inappropriate, and far too costly. These fees vary from operational to data requirement costs to research and execution fees. The Financial Times in 2017 estimated that the total cost of implementation would vary between 572 to 732 million for the EU. In addition, Justina Lee, a Bloomberg correspondent, said that research fees could vary between 1,600 and 1 million euros depending on the client. And from a management perspective, more and more firms were opting to pay for research fees themselves instead of passing them on to end investors. And in 2019, there was a 25% reduction of people employed as analysts in medium to large firms. Looking here to the right, this diagram is just an example of some of the new infrastructure and the associated costs firms have had to deal with in implementing this new regulation. Overall, the current regulation has come in for both praise and criticism. The rise in European saver participation in capital markets, the success of OTFs, alongside the widespread adoption of transparency regulation can be seen as a positive. However, the costs and the burden of research, fees and disclosures, alongside their effect on market liquidity and EU investment banks' competitiveness can be seen as critical failures. As a result, the European Commission and the ESMA have opened up a review process, and the results of this review process can be seen in the directive's COVID-19 amendment. This amendment has seen research unbundling, reporting regulations, commodity derivative trading rules, and call recording laws all relaxed in order to boost economic activity. I will now pass you on to Marcus.
Thanks, Rory. The case study we've chosen for our presentation is the London Interbank Offered Rate Scandal, also known as the LIBOR scandal. Prior to evaluating the LIBOR scandal, it is vital to get an understanding of what the term LIBOR represents. The London Interbank Offered Rate is a benchmark interest rate at which major global banks lend to one another on the international interbank market for short-term loans. LIBOR was set up by the British Bankers Association in 1986 to control the rate at which banks borrow and to authorize the data collection and governance process of LIBOR. LIBOR was established in a self-regulated manner, however this soon proved to be a mistake. For each currency, there is a panel of banks that submit rates, with most banks submitting rates for multiple currencies. The highest and lowest 25% of reported rates are removed, while the average of the remaining rates is obtained, which equals LIBOR. The LIBOR reference is then published each business day at 11:45 am after being constructed by the BBA with the assistance of Thomson Reuters, who are the calculation agent. To understand the significance of the LIBOR scandal, it is important to outline what LIBOR is used for. LIBOR is used for interbank products such as interest rate swaps, forward rate agreements, as well as futures and options. In addition to that, LIBOR is used for commercial products such as syndicate loans and variable rate mortgages, as well as student loans and individual mortgages. Additionally, LIBOR is used for hybrid products such as collateralized debt obligations and collateralized mortgage obligations. The benchmark rate also symbolizes credit risk within the market, as it represents the minimum degree of risk related to one bank defaulting. Dating back as far as 2003, multiple global financial institutions manipulated LIBOR to maximize profits. Initially, derivative traders within the bank would collude with the division of the bank that would submit rates, with the aim at benefiting the trader's trading position instead of actually conforming with the definition of LIBOR. This would then make the banks look more financially stable than that of reality. Traders at these financial institutions would then collude with other banks to influence the final average rate. They would work together to inflate and deflate the interest rate figures to get their desired daily rate. Consequently, financial contracts were mispriced. Banks that manipulated the benchmark were able to enhance trading profits and minimize payments associated with derivatives. The first allegations of LIBOR manipulation materialized in 2008 but were dismissed by the BBA. 15 global financial institutions then came under investigation by the US, UK, and EU authorities. In 2012, Barclays were the first bank to admit to allegations surrounding the manipulation of LIBOR. In August of 2012, Britain's financial regulator, the Financial Services Authority, launched a review on LIBOR's regulation with the aim of changing the regulatory approach of LIBOR. When evaluating the LIBOR scandal, it is important to pinpoint the failures that occurred under the self-regulation approach. The self-regulation approach was ultimately based upon trust among the financial institutions, However, this failed due to a lack of accountability and transparency over the benchmark setting process. A striking component of the scandal was the lack of supervision between the BBA, the division of the bank that submitted rates, and the division of the bank that placed trades. There was also a clear lack of trade reporting, which made it easier for market abuse to occur. Ultimately, regulatory change was inevitable following the break of the LIBOR scandal. The EU introduced a package for market abuse, which will be explored later in the presentation. In 2013, the European Commission published a proposal which included regulation on various benchmark rates. The International Organization of Securities Commission also published principles for financial benchmarks. We believe the administration of regulatory enforcement in the EU is a primary reason as to why the LIBOR scandal was brought about. The FSA did not have strict enough measures to disincentivize the manipulation of LIBOR. While the US had the Sherman Trust Act to help prevent antitrust behavior, the EU lacked disincentives to ensure banks would conform with the definition of LIBOR. The antitrust law in the EU was not stringent enough to disincentivize the manipulation of LIBOR. The European Commission made it clear that more often than not, victims of antitrust infringements rarely obtain reparation for the harm suffered. Therefore, this displays that there is a lack of regulatory enforcement within the EU and no incentives to conform with the definition of LIBOR. I'll now pass you on to Mark, who will discuss market abuse regulation.
As part of its work to make financial markets sounder and more transparent, in June 2014 the EU enacted new rules against market abuse. The Market Abuse Regulation came into force on July 3, 2016. This regulation rescinds the previous Market Abuse Directive of 2003, replacing it with extended scope. The original concept behind the Market Abuse Directive was to create a unified framework for the EU-wide market abuse regulations to ensure an effective and coherent informational workflow across the member states. In doing this, legislators hope to demonstrate robustness for outside investors and better cross-border cooperation. The Market Abuse Regulation outlines three main forms of market abuse. These include insider dealing, unlawful disclosure of insider information, and market manipulation. The idea of the new stricter form of market abuse legislation is to strengthen market integrity and investor protection and to guarantee a universal playbook across all EU member states. MAR not only fortifies previous legislation, but also enhances it by extending its scope to introduce new offences. By doing this, the regulation hopes to increase activity in securities markets. In generic terms, the regulation penalises insider trading, market manipulation, and unlawful disclosure of insider information. It gives national regulatory authorities the responsibility to detect and protect against market abuse, while instilling these bodies with the power to enforce sanctions against non-compliant parties. Insider dealing refers to the use of inside information to execute deals to one's advantage. This includes the execution of orders based on inside information as well as the cancellation and amendment of orders based on insider information. Importantly, MAR specifies that insider dealing not only covers the execution of trades, but also the amendment and cancellation of orders based on insider information. Equally, MAR puts measures in place to prevent collusion between third parties. The regulation also prevents persons with access to inside information from leveraging that information to encourage a third party to place, amend, or cancel advantageous deals. This includes offering up tips and recommendations to another person to place transactions based on inside information. Unlawfully disclosing inside information occurs when a person with access to inside information passes that knowledge along to another person. The only exceptions of this are if the disclosure is a regular facet of the person's employment or professional duties. The definitions for market manipulation are laid out in Article 12 of MAR. It refers to the act of misleading the market through certain activity or activities that manipulate the price of a security. In line with this, MAR specifically prohibits persons to place orders or behave in any way that offers purposely misleading signals regarding the supply, demand of a financial instrument or its potential price. To support this, it is also forbidden to produce and distribute information that purposely misleads the market on supply and demand or that indicates a false price. Extending the scope from previous legislations, MAR explicitly outlaws the market manipulation of benchmarks. Market abuse regulation does not refer to individuals or companies, but to financial instruments and behaviours of transactions. In terms of behaviours and transactions, MAR also covers certain types of bids. If the auction platform is considered to be a regulated market of emissions, allowances, or similar auction products, MAR applies. This is still the case if the products being auctioned aren't considered to be financial instruments. MAR encompasses not only financial instruments within the EU regulation market, but also any financial instruments which are dealt on OTFs or MTFs, since financial instruments traded on OTFs and MTFs can theoretically be based anywhere in the world. MAR's reach extends across the globe. The primary aims of MAR are to ensure integrity of financial markets and to maximise investor protection across Europe through a combination of new requirements and enhancements to the existing regime. These changes also seek to address some of the shortcomings identified with the regime during the financial crisis, such as the absence of an offence of attempted market manipulation, which is now included in MAR. Ensuring the correct protocol for the disclosure of information is vital to staying compliant with the market abuse regulation. There are various different activities which are required to be disclosed in order to maintain compliance with the regulation. PDMRs must notify the relevant authoritative bodies of all transactions once a predefined threshold has been reached within one calendar year. This threshold may be anywhere between 5,000 and 20,000 depending on jurisdiction. For investment recommendations, a disclosure of interest must include the recommender's identity, job title, and relevant authority. In order for full compliance, meticulous record keeping is essential, whereby information pertains to decisions made regarding suspicious activity. Records must be kept on file for 5 years. This refers to both reports where suspicion was deemed valid and those where the suspicion was concluded to be unreasonable. Permanent insider lists are reserved for persons within an entity who always have access to inside information, whereas event-based lists are for those who only receive inside information in relation to certain events.
Throughout this section, I will look at the aftermath of the LIBOR scandal. I will discuss topics such as the hefty fines for manipulation that banks received and the various LIBOR reforms that followed. Following the LIBOR scandal, the then CEO of the Financial Conduct Authority, Martin Wheatley, conducted an independent review on the various aspects of LIBOR. It was decided that LIBOR needed reforming and not replacing, as the value of the outstanding contract was 300 trillion and would cause financial instability if replaced. The most important recommendation made was to take the responsibility of LIBOR supervision away from the British Bankers Association. Following this recommendation, the Hog Tendering Advisory Committee decided to give the responsibility to the Intercontinental Exchanges Benchmark Administration, also known as the IBA. And on the 1st of February 2014, the IBA became the official administrators of the LIBOR, and it became known as the ICE LIBOR. Hefty fines were handed out to a number of banks for their involvement in the scandal. In April 2015, Deutsche Bank were fined a record $2.5 billion for their involvement as they pleaded guilty to wire fraud, and 29 employees were found guilty. 6 financial institutions were fined for their involvement in bilateral cartels in relation to LIBOR submission for the Japanese yen. Fines included €260 million for the Bank of Scotland. In December 2012, UBS agreed to pay $1.5 billion for their part of the scandal. UBS traders are found to have colluded with other banks and made over 2,000 submissions for movements in the rates between 2005 and 2010. In June 2012, Barclays were fined £290 million by UK and US authorities for their involvement. Barclays admitted to 2 types of manipulation. From 2005 to 2007, they took requests from their own traders so they could benefit from their own financial position. They also admitted to lowballing its LIBOR rate to paint a false picture of their financial position during the global financial crisis. The IBA simplified its LIBOR rate to make sure it was more robust based on underlying transactions, thus making it harder for banks to manipulate. Since July 2013, there have been 5 currencies and 7 maturities, 35 rates quoted every day, as opposed to 10 currencies and 15 maturities, 150 rates before the scandal. This makes it more likely that the rates submitted are underpinned by real trades. The rates that were terminated include the Danish, the Swedish, the Canadian, the Australian and the New Zealand rates, and this was done with little disruption to the market. Since July 2013, each individual submission that comes from a bank is restricted for 3 months. This reduces the motivation for banks to submit a false rate to portray a flattering picture of their creditworthiness. Banks also must have a named person responsible for LIBOR, so they can be held responsible for any wrongdoing. The Financial Conduct Authority announced that all LIBOR rates be phased out in Europe by the end of 2021 and phased out completely in the US by the 30th of June 2023. In the UK, the sterling overnight interbank average rate will replace LIBOR. In the Eurozone, the Euro short-term rate will replace LIBOR, and in the US, the secured overnight financing rate will replace LIBOR. The ESTR is an interest rate benchmark that reflects the overnight borrowing cost of banks within the Eurozone, and its rate is calculated by the European Central Bank. The ESTR is underpinned by an average of 500 daily deals totaling €40 billion. The ESTR is calculated more transparently than LIBOR, as banks must show proof of eligible trades. The ESTR includes a larger number of parties, thus meaning there is more transaction data available, and therefore the interbank rate is more accurate.
The current financial market regulation is certainly an improvement from MiFID I, however it is not without criticism. MiFID II aims at improving transaction reporting, investor protection, transparency and market integrity. The LIBOR scandal was a primary example of self-regulation failing. The regulatory reform that stemmed from LIBOR consisted of market abuse legislation, which aims at interacting with MiFID II by protecting investors and improving integrity within EU markets. On behalf of everyone in Group 2, thank you for watching our video.